Welcome, everyone, to the UC Berkeley Center for Law and Technology's webcast. Today, we have a wonderful presentation, material you don't hear a lot about. We're going to look at the patent landscape in Brazil, which those of you that have been around for a while know that 20 years ago, this wasn't really a webcast or an article to even pay much attention to. Today, you ignore Brazil at your own peril. But trying to understand what that means, what does it mean to ignore it versus embrace it? What do you need to know? So we went to the source and went straight to Brazil to bring you kind of a long-term partner of ours. So I want to introduce everyone to Rob Rodriguez from RNA Law out of Brazil. Rob, not only strong background in Brazil, but strong background here in the Valley. As much as I dislike it, he's a Stanford Law School LLM. Decent place. But I've been at Berkeley long enough. They teach me to not say good things about Stanford. But the reality is, when you look at the IP programs, Stanford and Berkeley turn out just great leaders. Rob is also, was the lead editor for the Stanford Technology Law Review, so deeply ingrained in the IP community here in Silicon Valley. When you look at his entire bio, you start seeing those markers of excellence. The Lexology, the Chambers ratings, the who's who and legal ratings. So you're really beginning to see, this great understanding of what U.S. companies need and what these U.S. companies need in a Brazilian market. So I'm excited to have Rob join us again. He was with us last year at the Advanced Patent Law Institute. So I thought we could press our luck and ask him for a little more of his time. So with all of that, Rob, appreciate you joining us here today. And I'm going to turn it over to you so you can tell us what we need to know about IP patent litigation in Brazil.
Thank you very much, Wayne. Appreciate your kind words. Appreciate the opportunity. You going there to try to find more about the jungle down here in Brazil. So it's a wonderful moment for us to share. Yes, I went to Stanford 10 years ago, and it was a very bright time for us because at that time McCaffrey was playing for Stanford, so we did have very good games against Berkeley and it was a fun moment. I've been practicing patent litigation for almost 2 decades already, and it's quite interesting how we did see things. We see things changing, right? For instance, when I went to Stanford like 10 years ago, we only had 1 or 2 cases filed in Brazil discussing standard essential patents, right? So we are right in the first wave of cases that I was able to participate, filing cases on discussing like SEPs in Brazil. And nowadays, this year, we are seeing in one single year 50 filings, right? So in 10 years, we saw something coming from 1 to 50, which is a very remarkable growing. And when I go to speak to clients and companies and even lawyers all over the world, they ask, why is that? And that's a lot of explanations. And we can start by how Brazil as an economy is developing beyond the agro industry, right? Brazil is primarily, for the past 20 years, a commodity-based country, right? So a lot of our industry oriented was around agro specifically, and we're growing a lot from that to become a more like an active community and big consumer market, right? So as the world opens more, Brazil becomes more attractive to those companies, and with them opening activities in Brazil, they also face litigation, right? So I guess one thing brings the other, and then on top of that, we do have a very strong IP system where preliminary injunctions, for instance, are available. So in cases where we see where we have a preliminary injunction practice very limited, and we know in the US how limited it can be, when you go to a country like Brazil, you do have a very high rate of preliminary injunction possibilities, and that with that brings opportunities for clients, for companies to enforce patents, right? So, and another thing of interest is the timeline from filing to trial has been also shortening. So we've seen cases moving faster. Right? Beyond this, the fact that you do have injunction availability, you have a pulsing consumer market. We also seeing faster trials. So this whole combination, it sees like how Brazil is becoming. I guess when 10 years ago, if you 10, 15 years ago, when you say you wanted to build a career in patent litigation, everyone will say, you are not very smart, right? Like, I say, okay, what do you mean by that? Of course, we did have already the pharma cases, but at the same time, like, wasn't like a practice. And nowadays, we have big firms with a lot of lawyers doing only patent litigation. So it's like 10 years ago, I would know the whole community. Nowadays, I don't know anymore. Like from 10 to 15 people practicing, you already have like 70 people, 75, and growing. So we see growing number of people interest on the difference. We know how this remarkable patent litigation it is because you combine different technologies. So you have cases on pharma, agrochemical, but semiconductor, computer science, mechanics. There's one thing about interesting about in Brazil is that most lawyers don't have a technical background. So patent litigation in Brazil is a combination between people with technical backgrounds, so the scientist, and a litigator like me, a lawyer. So I have a law degree, I have zero technical background, so we team up and then work. So this is a combination of this is what becomes a successful patent litigation practice. And only a few have a combined degree. So this is one of the one big difference, right, compared to other countries. And we also don't have like a jury trial system. So everything is decided by a judge. We don't have discovery as well. So a lot is paper-based and evidence-oriented based on the findings you can produce before filing a case, and at the same time produce during the case. But it's very limited for what you can learn from discovery, right? So it's very different practice. I did practice in the US. I did work in a law firm in the US for a time, so I understand a little bit of the nuance of the difference, and this is a major difference, right? The fact that we don't have discovery makes the system a lot like a strategic way of obtaining information and using that, leveraging that is a major thing. And one interesting thing that I can go ahead and share is this year we have one remarkable change. So if you think about the patent companies with patents, you not think about Brazilian companies, right? You think about American companies, European companies, Asian companies. But this year we had a Brazilian company that we are representing on the MedTech field filing the first UPC patent enforcement case ever filed by a Brazilian and a Latin American company against a German company. So this company that we are representing is suing a competitor in Germany and arguing patent infringement. So this doesn't look like much different, but when you realize that there's a change as well. So when I see that Brazilian companies are not anymore just on the infringer side, but also starting to realize, invest in innovation, get patents granted, they're also becoming active side, and not just in Brazil, worldwide. So this is a major, I'd say, on when you look at moments in your career that you need to see things are changing. I guess this year, this new development, it's quite interesting. Is a case. There's a bunch of if you look in the Google, you're gonna see a bunch of information. It's a very interesting case, And I wanted to focus a little bit on the idea that we have on preliminary injunctions, right? We are, of course, seeing, like, for instance, last week, there was a case filed by a Japanese company called IP Bridge, and enforcing a cellular patent, 5G technology patent, against car maker Geely, right? So IP Bridge put together a case and filed a PI against Geely, and the PI was granted last week, right? Ordering Geely to stop implementing the technology, and if they don't, then stop selling the car, right? This is one of examples of how much bigger is becoming, like, a Japanese non-practicing entities suing a Chinese, one of the largest car makers in the world, in a jurisdiction Rio, and obtaining a preliminary injunction. So this is a type of things that when you have to look at the framework and say, wow, things are definitely quite interesting. And then we receive a lot of questions like, okay, but what's going on, right? And first is we do have a very mobile-oriented population. So almost 65% of the population has coverage of 5G, and it's growing. And we do see, like, big companies like all of the Samsung, Motorola, Apple selling a lot of devices in Brazil. This is and this becomes part also of the economy. We have a very high population of streamers. So streaming is a major thing, like gamers that streaming games. This is a major thing in Brazil. So the connectivity is also generating this new thing, and this new, like, for the new generation, these new opportunities. And with that, we see a lot of litigation. And a couple of years ago, one of the major criticism, I would say, in the patent system in Brazil was pendency and backlog at the patent office, right? And a few years, the patent office made, like, a major, like, change in trying really to streamline and fast track examination. Is still a struggle. We're still not as fast as we should, but this is a good development. It's getting faster, at least. And then we see more patents being granted, right? So years ago, we have a backlog of 12 to 15 years. It's reducing. It's still not on the level that we want it to be, but it's something that it's happening, and it's quite interesting. And one interesting topic around that is we've seen the one of the big changes is how the local patent office is really wanted to be on the forefront of um, of uh, like setting up new examination guidelines. And a couple of months ago, it decided to issue for public comments AI related guidelines, right? How examination of AI inventions and in general, not just AI per se, but also technologies using AI should be examined. It's a lot aligned to what EPO was doing. I participated together with the U.S. IP Owners Association on a working group that submitted comments, and but this shows, like, one step of how the patent office is also trying to be harmonized with world other global patent office on how to examine these things, which we know is going to be very challenging, right? So it's a quite remarkable topic that we should definitely consider. Like, we are already discussing disclosure, how, like an AI model was used, this type of wording on the disclosure, is it enough to satisfy the sufficiency requirement, right? So the patent office already providing that. You need to provide more, right? You need to show, for instance, the structure of the data set, the correlation between the data and the input data and the output generated by AI. The pre-processing steps, including data cleaning, and normalization procedures. So we're seeing that one interesting thing is the training method, for instance. So we do see some concern for companies to address that. The other topic is inventive step, right? I still think that I don't think any office in the world knows how to handle this particularly. How do you gonna define inventive step on when you have AI actually helping the research? I think it changes a lot. What's the definition of even the definition of FOSITA, right? Because it's definitely changed research, but we see at least the patent office trying to put the house in order to be able to examine this case. And one remarkable thing on patent prosecution is we do have a grace period, 12 months. And the other nuance is claim amendment is still a challenge in Brazil. So there's a very strict, compared to any place I've been practiced in the world, very strict interpretation of what you can do after you request examination of an application. And anything you do that could sound like you're broadening the scope of your claims is going to be denied. And this is a very strong rule. So it's something for practitioner to be very aware. And we do have a bifurcated system where federal courts will hear validity challenges, and the infringement courts will hear, state courts will hear infringement, right? So this bifurcated system generates an interesting, because they don't interplay, right? So they either go in a different pace. There's sometimes some tentatives to make sure that they communicate, but it's not often that happens. And just today, we got a major decision for Johnson & Johnson on a case where we got a favorable trial decision ordering the competitor, granting J&J a permanent injunction against a competitor. And this trial was stayed because the appellate court said that in view of the process, the state court limited the ability of the infringer to allege invalidity as a defense. But that court, the appellate court, fails to recognize that the infringer was also seeking invalidity before federal courts, right? So what the company was trying to do is trying to attack validity on both fronts. And the appellate court, because of the process, decided to stay the trial. And today, actually, so this is a lucky day for this event, is we got the PI, we got a permanent injunction reinstated by the chief judge of the São Paulo State Courts, based on the fact that the validity court is actually establishing that a claim is valid. And based on the urgency, the granting of this PI is very relevant. So this is one example of the interplay, how these systems don't interact. So we need to really litigate cases in a different way. I guess it's very different from the US, where you don't have that. So you appear with different judges with different arguments, and you need to find a way to combine to get a victory for a client. So today was a very good day for us, where we were able to get this decision. And since we're talking about injunctions, this is also something that a lot of my practice, right? Injunction in Brazil, different from other countries, is established in the patent law, in the patent statute, right? So the Brazilian IP statute establishes that it's the right of the patent owner to obtain injunction relief. And doesn't matter if it's a pharma case, a medtech case, a SCP case, it doesn't matter, right? It's general right of the patent owner to get injunction relief based on likelihood of evidence, like the likelihood of winning on the merits, but at the same time, urgency, right? So this frames a lot the whole case, like how a case progresses in Brazil. And this also generates a lot of pressure on defendants, right? So defendants are struggling to understand, okay, how do I challenge this PI? And so what we see as our answer is, instead of being on the defensive side, we see a lot of defendant-initiated cases, right? So a defendant, potential infringer, file a DJ no infringement in another courts that has a lower rate of PI, just to be on the offensive side and avoid a PI threat. So this is dynamic of the system. It's quite interesting and remarkable. Another interesting thing is that our judges in Brazil don't have a technical background. So they're going to rely on what we call a court appointed expert, right? You have in the US a double type of system as well. So the court can appoint a technical expert, which is someone that the judge is going to rely on understanding the technical side of that, and then digest that as a report, technical report, to be prepared so the judge can take a decision, right? And then what you see is, in most of the cases, the judge is going to agree with this technical expert on matters of validity and infringement. So this technical expert actually becomes a major player in litigation, in patent litigation in Brazil, right? Because you need to convince him. If you lose a case against him, the chances of you winning is low. It's below 10%. And what type of cases are being filed in Brazil, right? Like, we do have a lot of streaming cases. I guess this is right now the largest number of cases on technologies such as AVC, GVC, and AV1. Just recently, there's a new AV1 case filed by Dolby. But we do have companies like Netflix, Amazon, Disney being sued in Brazil on infringement of patent rights. We also have a growing practice of non-practicing entities lawsuit, like the patent PAEs. I work with in the Mark Lemley group like a decade ago on an article that was published about the PAEs in the US, how they grew a lot in the US in the last decade. And now we see this number of cases filed by PAEs in Brazil also growing. This is something because of the PI system. So just as a matter of example, and going a little bit into the SCP world, a lot of clients ask us on friend arguments, right? So if you are an implementer and you want to raise a friend defense, like we see that in Germany, in Europe, you have the how is it type of defense, and in Brazil is still developing, right? So we are introducing on a case-by-case basis. But last week, there's a judge in São Paulo that issued a very interesting decision on a case filed by Acer against Nokia, where the judge understood that on a matter like that, it's not about just the patent infringement side, but also about the dispute, the contractual dispute. So it's interesting for the judge. He established like a bifurcated system where, before going to the technical merits of each patent, he wants to understand the negotiation and the friend negotiation. And one of the premises that established was comparable license. So this is something that we're going to see whether this will move forward, but it's a quite interesting development. And to finish here, maybe we do have the Brazilian Antitrust Authority, CADE, reviewing some of those SCP and litigation. There's one case a complaint filed by Lenovo against Ericsson, where CADE is investigating Ericsson whether there was abuse of dominant position on seeking PIs against Lenovo. And this case is under investigation. And we expecting a decision this year. And that will be a very interesting decision to watch. But Wayne, with that, I'm happy to address questions you might have, or keep going. Thank you very much.
Yeah, I did have a few, and I was going to start with the timing. You know, the timing in the U.S. is always horrific. horrifically slow, I should say. In what you're talking about for a patent case, you said it was quick, but if I'm looking at two things, how long from the start of a case to a preliminary injunction being put in place?
So for PI, we do have potential, like for next party, we can get in the same day, 24 hours from filing. But in average, I'll say a few weeks to 3 months, 6 months it's a estimate for PI to be decided both on trial level and conformed or reversed in appellate level. So it's a PI framework of 6 months to have what I can say, two decisions, right? A decision by the appellate board and a decision by the first instance judge.
In the US, if you're going to get a preliminary injunction, you have to post a bond related to the potential damages if you're wrong. Is there a bond requirement in Brazil?
Good question. It's not a requirement. Some judges might ask for that in terms of who you are. So it's not a requirement. It's discretionary. In practice, we don't see that happening that much. What we see actually is a company like the defendant asking judge to try to convert the PI on a bond, right? So they ask the judge whether they can post a bond. So instead of having the PI lifted for this bond. So this is how we're framing that.
Okay. Well, then my next question would be in this, the availability of any kind of discovery, especially for inventions that are hard to reverse engineer, hard to completely understand whether there's infringement or not. How would a patent owner go about getting enough information to prove infringement?
So good points, and that's very like part of my practice on how to do that, right? So one of the things that we've seen recently, it's more use of section 1788A2 in the US, right? So you have a litigation in Brazil, and then we file a section 1782 in the US to get access to certain documents, right? This is something that I'm seeing happening a little bit more. It allows for cooperation between evidence to be used in cooperation. So this is one example. The other one is by filing a production of evidence request. So you ask certain evidence to be produced, and it's actually at the discretion of the judge. So, and I wouldn't say that it's likely a discovery. It's more like a court order, and you need to be specific, right? You need to understand what you're trying to seek, and then convince the judge the importance of this to your case. So it's very oriented to some knowledge you need to. It's very hard, like for you to learn about something. So you're not gonna have in the pharmaceutical sector, for instance, you're not gonna have access to the whole dossier to understand whether there's infringement, right? If you need to show one report specifically to show infringement, then it's fine to ask for that. But the judge is not gonna give you like a blank check and access to everything. The same thing in telecom and other areas.
Well, then my last question would be, it seemed that when you speak about this, there was one topic that didn't come up much, and that's monetary damages, which always make U.S. lawyers happy because there's no injunction anymore.
Yeah,
more or less. I overstate that, but with the difficulties of the U.S. injunction, the system is turned on to dollars. That's just, you want to see monetary damages. You didn't put much emphasis on that, Rob. What's the status of monetary damages practically and I guess legally?
Yeah, in practical, we don't see much because in a system where you have a lot of preliminary injunctions, then parties settle, right? Because by the end of the day, you want to be able to sell work. So that becomes a huge threat for you. It's like the pre-trial settlement that you have a lot in the US, right? Once a party realize something, okay, this is I'm not gonna try to, and then they settle. The pressure of a PI makes parties settle, and so for the few cases that move forward, we have a few here. It's a challenge to obtain the information, like the accounting documents, so you can prove the damage. But in terms of calculation, at least the law, they provide that should be the most beneficial way for the patent owner. and it's a case-by-case basis. For instance, lost profits or entire market value. So it's a case-by-case basis, but usually, at least the law says it's on the most favorable way for patent owners.
Well, then that, I mean, makes perfect sense. It reminds me of the United States pre 2006, before eBay popped up,
Yeah,
when injunctions were almost a matter of right. And you saw cases get resolved rather than go through these massive damages,
yeah.
discovery processes, and all the appeals. So because PIs are so rare here, minus a few areas, question for you just on how cases typically flow. If there's a PI that's put in place, how often does that need to be converted to a permanent injunction, or does the PI drive settlement more often than not?
It's a good question. When you're hitting the right buttons, more often the conversion of permanent injunctions is so low because they settle. So we had in the telecom era, at least, I would say that it's the last years, like out of like almost 70 cases ever filed, 2 or 3 went all the way to trial. Like, and it's usually a background story behind that, right? Usually there's a way. There's not. It's not because it's something else. Either because the parties hate each other, so they don't want to settle for, and they're gonna go all in, or there's a case between GVX and Netflix, for instance, that is pending in the US as well. And then because of the background of the fight between the fight in the US and Brazil, they don't settle. Has a permanent injunction in Brazil confirmed by second instance. The party is still fighting, but it's very uncommon. It's usually the preliminary injunction practice after you had the confirmation by the appellate board is the moment that parties understand that they need to settle. And at the same time, if you are on the other side and you lose a PI, you can always settle, but you have less leverage, right? And that's a moment that maybe if you have another side, they look at it, okay, I might spend a lot with lawyers or I just pay this to go away. This is the moment for you to decide what to do.
So when you talk about how fast the Brazilian system is, it's fast if you go all the way through, but because the preliminary injunction is so important and that's so
Yes.
quick, the system's lightning fast compared to US.
Yes. So you can have a resolution in 6 months.
Perfect.
And a lot of that is I'm talking not just local resolution. Sometimes it drives a global resolution as well. Because if the client, let's see, you're speaking about a company that is invested a lot to start a big operation in Brazil, and they are hit by a PI, what are they gonna do, right? You have to settle. So right, like you get pressure from the business, you get pressure from the distributors, you get pressure from all over, and then they make you, okay, I'm gonna just pay you to go away so I can move forward, and we see that happening. At the same time, there's one interesting point that we see, but judges are very careful with public interest, right? Despite the high rate of PI, you need to make sure your case does not just jeopardize public interest in the sense that you're also showing that why, for instance, like a lot of the judges ask if, in the case of the telecom area, for instance, if the company enforcing the patent, it's a company that has other licensees, right? So if the licensor actually also have licensing for the companies, because that means the licensor is actually in good faith, right? The judges are careful and a lot of times to understand that you're not just awarding a PI to an unreasonable plaintiff. And in the PI practice, that's something the judge will always ask, okay, but am I hurting consumer? And is people gonna get out of jobs? So this is something that you need to be very mindful. It's not like because of the high rate of success, people think that it's easy, but there's a lot of that goes there.
So I'd love to follow up on that. I mean, technically, the U.S. has that public interest, and even pre 2006, they had the public interest. You could usually only find the examples of those cases in law school textbooks. That was just so rare. if that's a major issue for preliminary injunction, what happens if you win on the merits but have a public interest problem? How do you then get any value out of your patent?
So the law says that if your PI, for instance, is revoked, you have to pay back damages based on that revocation, right? So the law provides a system where you kind of have to be sure about your right when you ask a PI, otherwise you're going to pay that back, and the damage for that is very big. In terms of protecting public interest is conditional type of PIs, right? And some judges are actually considering, instead of like taking all the devices out, like just the old models, for instance. So allow, like it's a case by case basis.
And is it something the judge signals as I've got a public interest problem? You guys need to settle this
Yeah.
case or work it out?
Yes, for sure. In the hearings, for sure. Yeah. If it's depends on the size, it's often a background. It's often a background.
And
And
does
then
this
let's go on deep. This is an interesting topic, but there's also a concern about judges that see, but it's also on the public interest to protect a patent right, right? So there's no blank check to come here and just, oh, if I have to comply with this PI, I'm gonna have to fire people. The judge will say, yeah, but then if I don't protect patent rights, we don't have innovation, right?
Okay.
So that's why it's a case by case basis, because there's no blank check of saying that. The judge will understand how serious is the company applying for the PI, and at the same time, what's your efforts to settle and move, right? Why you're not just obeying. I guess it's how, at least, of course, in any system there's mistakes, right? We're not gonna say that it's a perfect system, but on my practice here, judges really try to understand what's the best for that case, and ended up that at least judges in Rio de Janeiro, where I practice most, they are really protecting IP rights in general.
Well, Rob, a fascinating system. So you can read all day about the Brazilian system, and you don't find these nuances in any of the writings on how things really work. So I really appreciate you being generous with your time and answering a few questions and sharing this intro material. For those that want to ask more, we've got Rob's LinkedIn information. You can reach out, send some questions. But this has been a great introduction to the modern reality of what anybody in Brazil can expect. So thank you.
Thank you, Wayne. Appreciate the time. Appreciate the opportunity. Berkeley, wonderful. And yeah, let's keep in touch.